So in this video, we'll be understand the Article 17, which is right to erasure. That means it is a right to erase the data. Who has a right? The data subject has a right. So Article 17 grant the data subjects the right to request the deletion of their personal data held by the data controller. Okay, it's simple. But the thing is, it is something which is under certain conditions. That means if the certain conditions are met, then only this right can be enforced. It is not something that the data subject has a criminal background and the record is held by the data controller. Now, in order to clear the criminal record, data subject can go and ask the controller to delete the data to exercise their right. So under certain condition means if the certain conditions are met, then the data subject can request for the erasure of the data. So we will going to understand what are the conditions are. So next, go to the next slide where it is written that the right to erasure allow individual to request the deletion of their personal data when certain conditions are met. This is a simple example we just read from the previous slide. So let's understand the goal is to give individual control over their personal information. The main goal is to give the individual, the data subject, control over their own personal data, especially when the data is no longer required by the controller. Okay, next go to the next slide where we can when can data be erased. So there are certain conditions under which the data subject can request for delete of the data. So first condition is when the data is no longer necessary. That means the data is no longer needed for the purpose which it was collected. So controller collect the data for the specific purpose. Now the purpose has already been achieved and data is no longer required for the controller. So in such situation, data is stored or archived in the database. In such situation, data subject can request for the deletion of the data. Okay, so next is withdrawal of consent. That means, so if the data collection was based on the consent and at that time data subject give their consent to collect the data, now data subject want to remove their consent. So if the processing was based on consent, then only it will be applicable. The example is, so you sign up a newsletter, now you decide to withdraw your consent. So you should have a mechanism in place where you can remove your consent and the data controller will know that you are no longer required the service or product or anything and you are removing your consent. So after that they will stop processing your data. Okay, so objection of processing means if the data subject object to processing under Article 21, we will going to read Article 21, and there are no overriding legitimate ground to continue. That means a user opt out targeted advertising and the company no longer has a valid reason to keep the data. If the data subject object to processing under Article 21 and there are no overriding legitimate ground to continue. It's simple. It's simple means that means a data subject, a user opt out of targeted advertising. That means there is a targeted advertising focused to the data subject. Now they opt out from the targeted advertising. And now this situation is happened that companies no longer require that data because there is no valid reason to keep the data because data subject already withdraw their consent, they raise their objection for processing activity. So in such situation the company can delete the data. Unlawful processing. Unlawful processing means the data has been processed, collected, whatever it is, processed unlawfully. That means a company collect personal data without proper consent or legal basis. So when we can say the data has been processed unlawfully if the collection or the processing activity has been done without any legal basis. This is a 100% case of unlawfulness. If the data collected without the data subject consent or any other 5 legal basis, then we can say it is an unlawful processing of activity. Okay, now legal obligation. The data must be erased to comply with the legal requirement under EU or member state law. For example, the telecommunication logs data or maybe the tax data from the employees. The organization are required to keep them for the 5 years at least for the tax related data, and after 5 years there is no regulatory requirement to keep the data, so they need to delete the data now. Similarly, it happened with the telecommunication log, ISP logs, where they are required to keep the log for at least I think 6 months maybe. So after 6 months they need to delete the logs, delete the data. So this is the legal obligation. Children data is the personal data was collected in relation to the offer of online services to the children signing up for social media. So that means if any online services is focused, the target audience is the children, and they have obtained their data, the children's data, without proper consent. So we already read that if the targeted audience is the children, then we need to take consent from whom? From their parent, if they are certain years of age, or this age limit is varying from different member state to member state. But if they are the children, so we need to take consent from their parent. So if the data controller has not obtained the consent from their parent, so in such situation the data can be erased. When data cannot be erased, so we understand when there are 6 or maybe the 5 conditions where the data subject can enforce their right to delete the data. Now we are going to understand when the data cannot be erased. A journalist publishing a news article that contain personal data, the data may be retained if the necessary protection free of speech. So that means in order to protect anyone freedom of expression and information, that means a journalist or maybe a writer, they write an article, they write a newspaper bites. So in such situation, in order to protect anyone's freedom of expression and speech, the data may be written. Just imagine this kind of thing happen when the journalist, they publish their article in the newspaper specifically related to the political party or political person, in order to share, in order to express their freedom of expression. Compliance with legal obligations, that means a company must retain employee salary data for 5 years. I think it's a 5 years, it will be 5 years for UK due to tax law. So that means they are required by law to keep the data for at least 5 years. So within 5 years, if the data subject requires to delete the data, it is not possible because it is a regulatory requirement. Now next, when can data not be erased? So the thing is public interest or public health. So that means when a research organization is conducting a research for invention or something related to the public interest. That means in the COVID-19, the lot of organizations, they collected the sampling from the patient, they collected the patient record to make some medicine, to make some prevention treatment. So in such situation, they need the patient data. It is for the public. So in such situation, the data cannot be erased. Archiving research statistical purpose, just like the previous one, public interest. Similarly, the research work statistical purpose, that means census data or scientific historical research data, you cannot, data subject cannot request for the deletion of the data because it is related for achieving a purpose, a research or a statistical analysis. And legal claims is something that a company retain data for ongoing litigation. That means if a person seeking a legal remedy, so in such situation, what is my duty? My duty is to keep the evidence against that person. So someone is filing a case against me in the court of law. So my duty is to keep the evidence, as many evidence I can collect and store with my custody, because I know, because they are going to sue me or something, file a case against me. So similarly happen with the company. If a customer going to sue the company or going to file a case against the company, in such situation the company may store their data, they can keep their return their data for the legal purpose. So this is the thing when the data cannot be erased. Even the data subject request the right or enforce their right to erase the data, in such situation also the company may deny their request to delete the data. How to exercise the right to erasure? So that means a simple procedure. The data subject requests the submission. The submission should be in written for the evidence purpose or accountability purpose. The data controller verify their identity, whether they are the authorized person or the original data subject, and within within undue delay. So every time we are going to see the time limit in the GDPR, every time we can see the without undue delay is the key point here. Without undue delay and the latest within 1 month. So every time without undue delay and latest within 1 month, the response time from the data controller. So they can respond the data subject that we are going to delete your data, and after the deletion process complete, they will notify that we have successfully deleted your data as per your request. So this is the key point, but they need to respond. The first response time should be within undue delay and latest within 1 month. Notification if the controller has shared the data with the third party. See, this is very important. Sometimes it happens when the data has been shared with the third parties, because for the processing activity, data controller is not a tech company, the processor is a tech company, and controller share the data with the processor. In such situation, the controller needs to inform the data processor to delete the data as per the request from the data subject. This is the example of right to eraser. The delete old account scenario. You created an account on an online shopping website, but you have not used in a year. Now you no longer require that website. So action, you contacted the company and request them to delete the account and all associated data. So outcome is the company delete your account and data unless they are legally required to retain, unless the tax details or financial details, if they are required by the law to keep, else they will delete your data based on your request. Let's go to an example of marketing opt-out scenario. You subscribe to a newsletter but decide to opt out and request the deletion of your email. The action, the company deletes your email and confirm the action. It's simple as that. So what is the right of data subject? So data subject right is the be informed about the right to eraser through organization privacy notice. That means organization privacy notice should include what is the data subject right. That should include the data subject right to erase the data. That means right to be forgotten, and be able to easily submit a request. That means they should have a mechanism in place which the data subject can use and send their request to the data controller. This should be a easy format like email or a form or something like that. This is all about the article 17, which is right to erase. It's pretty easy, so I'll recommend you to watch the video again if you have any issue to understand, and still if you have any issue, then I'm always there. Thank you, and if you like this video, do like and subscribe. Till then, take care. Bye bye.